वेलकम टू लर्न शॉर्ट एंड टाइपिंग विद विकास सर। स्पेशली हम पंजाब एंड हरियाणा हाई कोर्ट के लिए आपका प्रिपरेशन कर रहे हैं। मैं डेली की डेली आपको डिक्टेशन प्रोवाइड करता हूं, जो आपकी 80 वर्ड पर मिनट की भी होती है और 100 वर्ड पर मिनट की भी होती है। इसलिए आप अपनी तैयारी को अच्छा रखें और आपका दिसंबर में ही होगा एग्ज़ाम, इसलिए हम अपनी प्रिपरेशन को डेली अच्छे से अच्छे प्रिपेयर करें। और हमारी जो ये आपकी एक्सरसाइज है उसको आप टाइप कीजिए, ठीक है। और कोई भी प्रॉब्लम आती है आप मुझे कमेंट बॉक्स में कमेंट कर सकते हैं। सो बी रेडी एट द 100 वर्ड पर मिनट की डिक्टेशन होगी आपकी। रेडी, स्टार्ट। Whether an offence under section 138 of the Negotiable Instruments Act can be compounded after the confirmation of the conviction passed by the magistrate court by the appellant court and high court in revision? Question mark. Whether an order passed by the high court in a criminal revision petition confirming the conviction can be nullified by the high court in a petition filed under section 482 of Code PC noticing subsequent compromise of the case by the contesting parties? Question mark. What is the effect of the non-obstanted clause notwithstanding anything contained in the Code of the Criminal Procedure in section 147 of the NL Act? Question mark. These are the main questions to be considered in this case. It was held by the learned single judge of this court that offence under section 138 can criminal MC 1540 upon 2007 be compounded even after confirmation of the conviction by the High Court in revision, and considering the subsequent facts of compromise, necessary relief can be given in a petition under section 482 of the PC by this court. Another learned single judge of this court expressed doubt about the correctness of the above decision and thus referred this matter to the division bench. Para. Before answering the reference, we shall consider the facts of this case. A check issued by the accused for an amount of rupees 25,000 was dishonored for insufficiency of funds, and he had faced charges under section 138 of the NI Act. Stop. After trial, he was convicted by the magistrate court and sentenced to undergo simple imprisonment for 1 year with a fine of rupees 5,000. His conviction was confirmed. Stop. In appeal, but sentence was modified and he was sentenced to undergo simple imprisonment for 3 months. In revision application, this court by order dated 23/3/2007, confirmed the conviction, but sentence was modified to imprisonment till rising of the court and to pay a compensation of rupees 25,000 under section 357 bracket में 3 of PC. Stop. Thereafter, his petition was filed in May 2007 under section 482 of the Code of Criminal Procedure by the accused petitioner for the following reliefs. 1 bracket close. To accept the compromising application jointly filed by the parties, and bracket close 2 to return the fine amount of rupees 5,000 already deposited before the magistrate court. In the joint petition by the parties accused and complainant, prayer is as follows. Stop. In the above circumstances and in the interest of justice, this honorable court may be pleased to permit the petitioners to compound the offence and acquaint the first petitioner. Full stop. Counsel for the petitioner relied on the decision of Sabu George Supra for allowing the petition. Stop. But learned single judge was of the opinion that order of conviction became final by the order of the High Court, and hence he cannot be acquitted in a petition under section 482 of PC, and doubted the correctness of the above decision with the following observation. The legal effect of allowing this petition by invoking the inherent power of this court would be to affix the conviction entered and sentence passed by this court in criminal revision petition number 667/2000, which in the normal course could have been interfered with only by the Supreme Court in appropriate proceedings. Apart from the fact that the consequence which is sought to be avoided by the accused is not one following from the proceedings of an inferior court, the course now sought to be resorted to appears to be impermissible in the light of the decision of the apex court. Moreover, a reading of subsections 4 A, 4 B, 5 and 6 of section 320 PC would indicate that compounding can be had only in a pending proceedings and with the permission or consent, as the case may be, of the court, even if the offence is one compoundable without the permission of the court. Stop. In the case of offence falling under section 2 of